Hey everyone, thank you so much for joining the podcast today. Today we have on Matt Baum, financial services attorney, partner at Fox Rothschild. It's a law firm with coast to coast reach in the United States. I wanted Matt to come on today for a couple different reasons. Number one, he has an awesome reputation in the broker dealer and RIA space. But number two, because picking your attorney when you're doing due diligence to transition to a different firm is arguably just as important as picking the right firm. And just like any other service advisor, any other service provider out there, not all attorneys are created equal. And the goal of this podcast is just to give you an understanding of the landscape and just make sure you have the best possible attorney by your side during one of the most important times in your professional career. Matt, I really appreciate you coming on the podcast today.
Oh, thank you so much for having me, Corey, and couldn't have asked for a kinder introduction, so really appreciate it.
Absolutely. If you don't mind, before we get started, just telling everyone a little bit about yourself and kind of where you got to today. You're pretty well known in the industry. They'd love to hear it.
Oh, thank you. But happy to. And, lawyers love nothing more than talking about themselves, so that's an easy one. The first thing I will start with before I get into that, Corey, of course, I just have to list some typical disclaimers. Everything I speak about today is meant for general informational purposes only. It shouldn't be construed as legal advice, tax advice, investment advice, shouldn't be relied on for any reason or purpose. But I'm hoping to have a valuable conversation today to give people some ideas and thoughts and insights. Also, this could be considered attorney advertising, so I'll throw that disclaimer in as well. So now going back to me, since I graduated from law school, I've always been involved in the securities industry. My practice today is highly focused on that. It's not all I do, but it's the vast majority of what I do. And my representation is of broker dealers, financial advisors, and RIA firms, and that's the core of what I do for a living. And I'm a litigator by background, so that's really the flavor and insight that I bring to pretty much everything that I do. I've represented clients in well over 100 FINRA arbitrations. I've represented hundreds of advisors in transitions. I don't keep count. In some ways, I wish I did. It's kind of like the McDonald's sign, X number served, and we could kind of keep track of how many moves we've done over the years. Most of them have been extremely successful, of course, which is great. Obviously, some have had issues. Some of the ones that have had issues were ones we didn't necessarily give them pre-transition guidance in, but we were brought in to help resolve the matter in some capacity. And as part of our practice, we handle litigation, we handle arbitrations, both industry side, customer side, registration issues, licensing issue. We deal with termination issues, sensitivities, U5s, U4s, dealing with those types of disclosures. We help folks in connection with transitions, setting up entities and going independent and all of the different iterations that go through that. And then, of course, in the last few years, we've been very active in the M&A space, helping folks buy and sell practices. So we really cover a lot of ground, and I'm very fortunate to be part of a large law firm with a national platform. As you had mentioned, we have 1,000 attorneys, 30 locations nationwide. So where we help folks nationwide in our transition practice, I'm able to harness a lot of the talent we have throughout the firm for labor and employment issues that may be specific to a jurisdiction, corporate issues that may be specific to a jurisdiction. So we're really able to use that as part of the transition practice. I'm going to stop now.
No, yeah, it's fine. I mean, there's definitely benefits of being part of a national firm. I mean, I guess my first question for you is the geographic location of your attorney important when you're doing this process? If there's somebody in Iowa that's looking to make a transition and, the attorney is in, Louisiana, does that put a financial advisor at a disadvantage?
It really depends. So let me start with the following. I would say that there are two primary aspects that go into analyzing a transition from a legal perspective. One is what I'll call more securities industry oriented. For that, if you have an attorney who has experience in the securities industry, whether they're in Alaska, New York, or Florida, I don't think it necessarily matters if they have that experience and insight of dealing with firms, understanding transitions, understanding how certain firms have nuances, different reactions to certain types of conduct, et cetera. Where the specific jurisdiction can matter is if you're trying to analyze, let's say, a restrictive covenant, and perhaps there's a nuance of a particular state law that you really need to harness. There have been times where on transitions, because it's a jurisdiction that our firm just doesn't have someone licensed in, or we have no familiarity with and can't really assist, that we may not be able to take on the assignment. But by and large, we have a pretty robust ability to handle most transitions. I would say the overwhelming majority that come in our door.
Yeah, but just like a single, man or woman law firm that's in one place versus and doing business across state lines, it seems like there could potentially be some benefits of being, aligning yourself with a national firm.
Oh, I mean, look, self-servingly, I would tell you I could sing the praises all day long. There's so much, just as I mentioned in the opening, that we can bring to the table and capabilities and disciplines and practice areas. A lot of attorneys hold themselves out as a one-stop shop.
Mhm.
But there's the classic, master, jack of all trades, master of none.
Yeah,
And I think you're far better off staying in your lane. You are, superior in terms of your experience in a specific area, a
yeah,
specific lane, but you want to harness the talent of others who bring other expertise to the table.
for sure. And that's really the reason why I wanted you on the podcast today, because sometimes when I'm helping a financial advisor, leave or I'm following up with them, after they make the transition, I'm just really surprised sometimes the attorneys that they're using. And you said it before, jack of all trades, master of none. I
Yeah.
mean, I'll just give you a couple examples. I recently just had a terminated advisor from an employee firm, had to move really, really quickly. And he wound up just using, his friend that was an attorney down the road, like barely did any financial services work at all.
Yeah.
And, things like that put people at, a significant disadvantage. Or
100%.
or also as well, when especially at larger firms, when a financial advisor is going through the due diligence process, a lot of firms have, relationships with attorneys that will review their rep contract, analyze their risk, and most of the larger firms, they'll actually pay for that consultation, but I feel like sometimes they don't put a lot of significant thought into the actual attorney that they put in front of you. And I just wanted to have you on today to just maybe help better equip financial advisors to, maybe ask a few questions and, help them identify, who the best possible attorney can be, for making a transition, especially when there's a larger risk of legal repercussion.
Yeah, and I think you raise a great point, Corey. And I could go on for the rest of this podcast just on this one topic, but I'll try to keep it brief.
It's important.
It's very important. The first issue that you kind of raise, and we've run into this all the time, and frankly, we've been brought into representations because of these mistakes, where an advisor uses their college buddy or their neighbor who happens to be a lawyer. Just like we spoke about stay in your lane, you stay in your lane. If you don't do this, if you don't have the familiarity with the industry, the norms, the customs, how these cases get litigated, which I'll put a pin on in a moment and speak about that too. The selection of counsel is paramount. Can your college friend read a contract and tell you what they think it means and maybe apply state law to it? They can technically do that, but that's not what you're looking for. That's a part of what you're looking for. That matters. But what also matters is, like, in this industry, what matters? What are the norms? What are the customs? What do firms react to? What do firms care about? What should an advisor do or not do? How should they deal with resignation day? How should they deal with pre-departure communications, post-departure communications? That's not in the contract. That's experience. That's the industry. So using someone who has a lot of experience in the industry, I think, is key. On the vetting piece that you speak of, it's unfortunate in my mind and often leads to bad results when somebody thinks of attorneys as commoditized, right? Well, you're an attorney who does this, so you could help me. Well, not all attorneys, as you mentioned before, are created equal. Your move in your firm, there are some advisors who have moved many, many times. I'm sure you've had repeat business, Corey, over the years with advisors who have come to you 3 times already, or whatever the case may be. But for the most part, people don't hop around all the time. You may have a few moves in your entire career. And this is your business. This is your livelihood. This is how you make your money, support your family, put food on the table. Do you want to entrust your move, the success of your move, which could be defined as clients following you, avoiding legal issues, and otherwise, with just a name out of a hat? Or do you want to vet it? Do you want to feel comfortable with the person you use? When I speak with prospective clients all the time, I don't push myself on anyone, and you need to work with who you feel most comfortable with. That is paramount. And if you feel more comfortable with someone else, great. That's who you should use because at the end of the day, this is going to be your guide through a very important process over your business, a very valuable thing that you worked your whole career to build.
Yeah, I think it makes total sense. And I mean, it's not just someone, I mean, kind of the first layer is someone that is majority focused on financial services. I think that's extremely, extremely important. But I think another, question to ask, especially if you're making a move from a firm that just has a record of whether they're, not part of protocol or they just have, a record of litigation. I mean, just asking the attorney, how many times have you helped someone from my firm, successfully move to another firm because
Yep.
just like a recruiting consultant like myself, someone that's helped 300 people move from one firm, they're going to have so much more insight than someone that's just moved a couple. I think it's very much the same with attorneys.
Yeah, and I think you're raising a very important point, Corey. And I want to underscore it. We spoke about using someone who isn't quite in this industry because you know them and they happen to be a lawyer as probably a pitfall and a mistake that we've all seen play out. And I could tell you war stories of problems people have had by following just bad advice.
Yeah.
But aside from that, there are folks who are focused on the securities industry, but they're not litigators.
Mhm.
And I think that's another mistake that I've seen occur because when we are brought in to many of these transition processes, I've litigated against those firms over these issues in many instances. I know how they litigate. I know how they argue certain behavior. I know how they try to interpret their own contracts. I'm not saying this I. It sounds like I'm the only one in the world who knows this, and I'm not trying to paint it that way. I'm just saying if you have that experience where you've faced in a litigation that firm over these very issues that you're counseling a client to hopefully avoid, right? We're talking about a preventative counseling representation. You're in the best position in many cases to give that advice as opposed to someone who, the minute things don't go well, say, well, I'm not a litigator. I can't help you from here on out. Well, that's great. You did half the job. That may not be great for the advisor at the end of the day.
What percentage of attorneys that do what you do you feel like don't do litigation and just do preventative? Is that
I
a pretty
can't
big?
I can't put a number on it,
Mhm.
but I've encountered a number of advisors over the years who have told me they've gotten advice from someone who clearly focuses on securities industry work, if you looked at their website bio, for example,
Yeah.
but who have said when things go wrong in that transition, I can't help you. I don't litigate. So I
Yeah, I
can't put a
mean,
number on it, but there are a number of folks in the space who do give that advice who don't litigate.
yeah, I mean, this is super, super important. I mean, I've seen selecting the correct attorney, and obviously there's other factors involved. You could only, just kind of guess, but with especially with a non-protocol move, having the right attorney versus, the wrong attorney. I've seen, people bring, north of 90% of their assets versus 30% of their assets. And I'm not saying it's entirely due to the legal advice, but I'll just give a really specific example. Recently, I reached out to a financial advisor just to see how their transition was going.
Yeah.
And it's a non-protocol firm that's just losing a lot of financial advisors right now. And basically, this attorney basically just gave them advice that pretty much they need to resign, move to their new office, and literally sweat and look at their phone and hope that their clients reach out to them, which very much isn't the case. I mean, there's definitely certain ways that you can still communicate with your clients within the laws of the guidelines of non-protocol. And I mean, if that advisor had the ability to get in front of someone that had tons of experience moving from that firm, I feel like his transition would have been much, much different.
Yeah, and obviously I can't speak to whatever the contract was at issue in that particular
Yeah.
case, but as a general matter, I think it's challenging when an attorney is absolute in advice, like absolutely do nothing. That would be like usually you want to speak about risk spectrum and advise a client, if you do this, here's your risk. If you do that, here's your risk. Obviously, honor your contract is always the paramount advice.
Hmm.
But obviously understanding the nuances of what that means, that's the key to the representation. And I think at the end of the day, the success of the transition, the burden of the success of the transition is primarily on the advisor, right? It's their book, it's their relationship, it's their business that they built over the years. They have whatever level of rapport they have with their clients and don't have whatever level of rapport they have with their clients. But you certainly don't want to feel like the attorney got in the way of the success of the transition.
Yeah,
You want to liberate them so they're set up for success in the process without obviously finding themselves on the other end of a lawsuit.
sure. I don't know if this is a question you can answer or not, but you know, broker dealers typically will provide an attorney to, review a rep contract, review some of the risks, and that's a great, service that they provide. I mean, do you recommend that, financial advisors kind of go out and just, seek their own attorney as well for some sort of second opinion?
It really depends. It depends on what you're getting and what the arrangement is. You could have an arrangement where an attorney is limited in how much time they can give you. Um, you don't want to cram this type of thing. When we do transitions, the way that we structure them, we give you fundamentally unlimited access to us. Now, there can be abuse of that. I've never had it before because we set the proper expectations.
Mm-hmm.
But you don't want to feel like, oh, I better not make this extra call because now the meter's running or something like that, which could
Yeah.
be a thought about attorneys. It's too important. And so if you're being provided with a limitation, you might want to think about paying for more. Even if you like that person who's giving you the advice, if they can only give you a certain amount of time, maybe it's worth paying up.
Hmm.
Similarly, in some cases, if a firm is providing this to you for free, that could be fine. I'm not saying there's necessarily a problem with that, but free does not equal quality necessarily. It could be. You could get a high quality person and you're thrilled and you feel like they're experienced and you feel like the advice they're going to give you is going to be valuable.
Hmm.
But if you don't feel like it's great, don't fall into the trap of saying, well, it's free. So why should I go out of pocket for an attorney when here's someone who's clearly vetted by some firm at some point? They must be decent or they must be good. We have absolutely obtained clients who have had those situations are like, I don't feel great about this. I want to talk to someone else.
Yeah.
So it depends, Corey. I don't want to give an absolute on this because you can stumble upon a good opportunity and a good relationship there.
Yeah.
But I think you need to have your antenna up, and I think you need to be honest about like, am I getting what I need right now?
Yeah. Yeah, I just think it's important for financial advisors to understand that you have, choice in this matter. A lot of independent broker dealers, they just don't have relationships with one attorney firm. I mean, you're going through this process and you're spending, 50, 100, 200 hours, figuring the right firm and figuring out your lifetime partner. Just a little bit further effort, just asking some of the questions that we talked about today. Do you handle litigation? What percentage of your business is financial services? How many people have you helped in my exact position, move from this firm? Just kind of asking some basic interview questions could just really help you have a much more successful and less stressful transition in my opinion. But um,
Agreed.
can you just help a financial advisor kind of understand what an hour spent with you in this process or more what looks like?
Sure. And it's rare that you would only spend an hour with me, for
Yeah.
better or worse. I get
Yeah.
it. It's some people feel like speaking to a lawyer is like going to the dentist, but our hope and desire is that you walk away from every call feeling more and more confident and feeling like more of the things that are running through your mind are now calmed. And that's always my goal on any call. Usually the way that I structure it is many calls throughout the life cycle of a transition. So let's say you've got 3 months before your anticipated break date. We're going to have regular calls. The first call is probably going to be a lot of overview material. It's going to be talking about what are we going to be talking about? What are the issues we care about? What are some high level thoughts? And most significantly, and I start every call this way typically, what's on your mind, Corey? right? What are you thinking about since we last spoke? What are you bothered by? What are you trying to work out? Let's work through that because that's what's been bugging you. That's what's been stressing you. It's about you. It's not about me. But I, of course, go through the various things that I always want to go through to vet the various sensitivities that would go into a transition process.
So Matt, I mean, this isn't really a fun thing to talk about, but you do the preventative work in the beginning to help lower a financial advisor's chances of, having any legal repercussions from a broker dealer or RIA. What happens if, in the small chance they wind up getting sued? I mean, what does that look like and how do you help from that standpoint?
Sure. So there are a couple pieces that go into this. There's an injunctive piece that could potentially exist in one of these disputes. The dirty acronym TRO, temporary restraining order, that people talk about in the space all the time.
Hmm.
What is a TRO? And a lot of times people are confused about it. It's really a court saying honor your contract, fundamentally, right? So if your contract says ABC, then the injunction should say you need to do ABC or you need not to do ABC or whatever the case may be. So the idea is, as a general matter, the court is not imposing more of a burden on you than your contractual obligations are. But now you have a court saying you better beware that you're not violating your contract because now you're in violation of a court order. That's one piece. The second piece is monetary damages, right? So that's more to just stop whatever behavior the firm is claiming you did. And by the way, it doesn't mean they win just because they file for a TRO. That's the whole point. You go in, you hopefully try to defeat it if you're on the defense side, or work something out that everyone can live with on a stipulation basis, like an agreement basis. The secondary piece is monetary damages. They're suing you over the assets at issue or whatever the conduct was at issue and how they were damaged in some way. That piece in a broker dealer setting is handled in FINRA arbitration.
Hmm.
So you would be in a FINRA arbitration process, and that process takes however much time it takes. If you're in an RIA setting, it could be a different arbitration forum. It could be like AAA, the American Arbitration Association, or it could even be court.
Yeah.
And the case is litigated in court. So I kind of think of it as two pieces, a potential injunctive piece. Firms don't always go for that, by the way. Even if they think you're engaged in wrongdoing, they may just file an arbitration and that's it.
Yeah.
Or they go for the injunction. It really depends. But those are the two things that you're dealing with, likely as possible outcomes if things don't go the way you want them to go.
Sure. Um, so I think one thing, financial advisors need to know, um, I think every financial advisor's biggest fear, especially coming from a non-protocol firm, besides are my clients going to come with me? They're going through this process, they get a cease and desist,
Mhm.
and a month into their transition process, they literally need to, take their hands off of the computer and, them and their clients are kind of stuck in limbo. But that's not necessarily the case. A cease and desist doesn't necessarily mean you need to stop bringing over clients, does it?
A cease and desist means you want to have representation at that point and you want to know how you should conduct yourself accordingly,
Yeah.
right? Because a cease and desist is a lawyer on behalf of a firm saying, stop what you are doing. It's not the same as a court saying, stop what you're doing, for example. And that's why
Yeah.
you really need representation at that point to guide you on what's going on, where things stand, what you should be doing, what you shouldn't be doing there going forward. And it's all very fact-based, Corey. It really depends on the circumstances at that point.
Are you allowed to give any sort of like, we're probably not, but like stats in terms of like, out of 10 transitions, how many, wind up having some sort of legal action against them? Is that something you're allowed to say? It's fine if you're not.
Much like I don't keep count of how many transitions I do. I don't have
Yeah,
exact statistics, but I would say the vast majority of matters don't have meaningful post-departure issues of the ones that we've been involved in.
that's great. That's great.
But I want to be very careful, and lawyers have to be careful about this.
Yeah.
Past results don't indicate future outcomes, but as a general matter, our experience has been most of the transitions we're involved in don't have meaningful legal repercussions afterwards.
Yeah, I think it's a good thing to know that a large part of these don't wind up in arbitration. I don't think that makes it any less scary for a financial advisor because there's always that what if in the back of your head. But I mean,
No, it's worse than that, Corey, and I don't mean to interrupt your flow.
yeah,
If you're in the minority of the folks that have to deal with a legal issue, it becomes everything to you.
yeah,
So it's one of these things where you could take comfort. Hey, Matt's told me the vast majority of people he's worked with, it hasn't led to anything. But if you're in that minority, that's going to become very important to you. And by the way, just because you're being sued doesn't mean there's any merit to the lawsuit, of course,
yeah,
but you're defending against it. And lawsuits tend to be very emotionally taxing and candidly financially taxing.
yeah,
You're paying a lawyer to defend you. You're paying for a lawsuit. You're paying for all of these different things that go into a lawsuit. It's the toll, it's the distraction from your business. It could interfere with your whole transition process. Litigation can be all encompassing for folks. So it's one of these things where, you can take comfort that if you do things the right way and you honor your contracts, you should be fine.
yeah,
But if you're not, either you want to make sure you're in a very defensible spot, but dealing with a litigation, even if you feel very comfortable with how you're situated and what you've done, and that they're just falsely accusing you of doing things you didn't do, you're still spending time, money, and distraction on that case. So it's still very significant because you don't know which pool you're going to be in at the end of the day. A firm could get a wrong idea and pursue an advisor who did everything right.
yeah.
That's just the way it goes sometimes.
Yeah, and I mean that's why it makes total sense to work with, an advisor that can work with you, preventatively, and then,
Yeah.
also proactively as well if things kind of go wrong on the other side. That makes 100% total sense.
Yep.
But Matt, I really appreciate the time. I think this is so important. I think you did an awesome job of just kind of outlining some of the things that financial advisors should consider. If
What I
financial
do.
advisors want to, if financial advisors want to reach out to you, how do they get in contact with you?
You could email me at my firm, mbaum@foxrothschild.com. That's probably the most efficient way to get me. The other thing you could do is you could call me at my firm. My direct line is 212-878-1429.
Awesome. And for any advisors listening, I've helped do this over 1,000 times. I've built some really good relationships with, attorneys, and based from the firm that you're coming from, I could definitely point you in the direction of a handful of attorneys that are very much experienced going through what you're going through, right now, and really just help equip you with some questions to ask, to determine who the right fit is. As we said before, this is equally as important, as finding the right firm as your long-term partner. So I really appreciate the time, Matt. And if anybody has any questions, my contact information is all over my YouTube page and my podcast page. And I'd love to talk. Matt, I hope you have an awesome day, and I really appreciate it.
Thanks so much for having me, Corey. It was a pleasure.